I'm going to talk to you about an I-9 inspection process. It's also known as an ICE audit. The Form I-9 is part of the Immigration Reform and Control Act of 1986. It requires that employers check the employment eligibility of their employees, and it creates a criminal and civil sanction for any employment-related violations. So the I-9 form itself, it's also known as the Employment Eligibility Verification Form. You're required to have an I-9 form for all your employees within 1 year of their departure from your employment, or for 3 years from the date of their employment with you, whichever is longer. Now, if you receive a notice letter, a notice of investigation from ICE, you usually have 3 days to comply. And compliance means you will show the ICE agent your I-9 form and your supporting documents for all your employees. The ICE agent will take their time and review it, and two things will happen. You will then receive one of two letters. One is a notice of suspect documents, and two is notice of discrepancy. It's your job as the employer to correct all the deficiencies identified by the ICE agent. At this stage, you will have either a violation or you have full compliance. If the investigation shows that you are in full compliance, all of your I-9 forms are filled out correctly, and you have the supporting documents, the I-9 investigation process will end for you. Now, if there's a violation, you will usually have two types of violation, and you'll receive a letter. You will receive a letter that identifies it. One is a substantive violation, or you will have a technical violation, at which point you will have a fork in the road. The ICE agent, the agency, will make a decision on what to do about your violation. They will then issue you, one is a warning letter, which is what you want. If you don't have full compliance and you're in violation, a warning notice would be fine, because you don't have to pay any penalties and you don't face any criminal sanctions. Number two is you could get a notice of intent to fine. A notice of intent to fine is something that most employers are concerned about, because there are civil fines that are associated with it. I've seen civil fines that ranges from $375 to $16,000 per violation. Now, the amount varies based on how many employees you have, the type of violation, and whether or not you are a repeat violator. Once you receive, or if you receive, a notice of intent to fine, you will have 30 days to either settle the case or file an appeal.